Business contracts. What are business contracts? A business contract is a legal agreement between you and another party and may be used in situations where services are rendered for a free or specific duty and are required to be where free or specific duties are required to be performed. Essential elements. In order for a contract to be legally binding, it must have these 4 elements: an offer, acceptance, intention to create a legal relationship, consideration as well. There are some cases where a contract can still be considered valid, and they are if it entices someone to commit a crime. A person doesn't have the capacity to understand or uphold the contract, and or the contract was agreed through misleading or devious conduct, duress, or undue influence. Types of contracts. Contracts can be verbal or written, or a little bit of both, but some contracts do require one over the other. Written. A written contract is a written or typed and consists of a standard form agreement or a letter confirming the agreement. Verbal. A verbal contract is a spoken contract and it relies on the verbal faith of both parties, but can be very difficult to prove. General terms and structure of a agreement. Most contracts do not have formats that they must follow, but do include terms that are expressed or implied that help form the agreement. The terms that form the agreement. The terms of the agreement usually are outlined in conditions of the contract and warranties as well. Contract conditions. These are the fundamentals of the agreement. If the conditions of the contract are not met, termination of the contract can happen, and those involved can seek compensation. Contract warranties. These are not seen as important as the terms of the contract and are not fundamental to the agreement. There is no way to terminate a contract when warranties are not fulfilled, but you can seek compensation for if a loss happens. Standard form contracts. Standard form contracts are one of the most used form of contracts. They are pre-prepared contracts that have the terms set in advance, where they just require names, dates, and signatures. Here are some examples of standard form contracts: employment contracts, lease agreements, insurance agreements, and financial agreements. These contracts usually benefit the one who is offering the contract, and there is little or no negotiation between the parties. It is important to read through these contracts as the fine print may be missed. Before signing a contract. Before signing a contract, you must read every word, especially the fine print. That's where things get missed, and usually agreements, things that people agree to, they really don't know that they have. Make sure that it is what was negotiated. Seek legal advice if needed. Do not leave any blank spaces. Initial any changes, both parties, and obtain a copy of the signed contract for your records. Here is a case where contracts did not uphold. So Wood versus Boynton. A quick overview of this case is that a woman owned a stone, and she wasn't able to identify it, so she sold it, the stone, and she only sold it for the value of $1, not actually knowing the actual value of the stone and that it was a diamond. She wanted it to be returned, but the person who bought it refused it, so she brought suit. And in court, neither P nor D had any knowledge that the stone was a diamond, so there was no fraud. In addition, there was no agreement of the warranty. Either either it wasn't stated or implied. Therefore, the risk was equally borne by both the buyer and the seller could not rescind on the sale. So since there wasn't a warranty, there wasn't an agreement in place, there wasn't a written one, and it would be hard to actually prove that there was a verbal one. She didn't have precedence to have the stone returned to her. This is where lack of knowledge and seeking legal help would come in. Here are my sources. I hope you learned something while watching my PowerPoint on contracts, and I hope you enjoyed it. Thank you.